Hello and welcome to Topic 8, Lecture 1. And in this topic, we're going to be learning about police and the rule of law. All right, so what are we going to be covering in this lecture? Well, first we're going to talk about civil liberties and its relationship to criminal justice. And then we're going to dig into the Fourth Amendment, because that's what we're going to be focusing on both of the lectures this week. And so we're going to look at the Fourth Amendment and the two clauses that make up the Fourth Amendment. And then we're going to talk about what constitutes a search and what are the requirements for a warrant. So that's what we've got on the docket for today. So let's get started. All right, so last week we discussed the challenges associated with policing in a democratic society. We talked about how it is easier to fight crime and to police in a authoritarian state or in a totalitarian state, because government has little to no limits on its power. So they can search whoever they want. They can, charge people however they want. They can, try and convict and punish people however they want, because there are no limits placed on their power. But we live in a constitutional democracy where there are clear limits that are placed on the powers of our government agents and our governmental institutions. And so obviously it becomes more challenging to fight crime and keep order, because it has to be done in a way that it corresponds with the limits that are placed on government and the protection of individual rights. And so, we're always trying to strike this balance between security and justice. Of course, you want to live in a society that's not overrun with crime, but we want to make sure that we achieve the goals of crime fighting and apprehension and punishment of those who have committed crimes. We want to do that in a way that corresponds with the values of justice. And so this week, you'll be learning about police and the rule of law. Because police are on the front line, we know they're the gatekeepers to the criminal justice system. It's extraordinarily important for the police to be governed by the rule of law. And as I was grading your midterm exams this past week, a lot of people were bringing that point up, that they thought that one of the most important steps in policing was the initial contact, because it's really important that the initial contact takes place in a way that is legal and accords with the law, and same with an investigation. It's very important because if the police screw it up and they don't follow the rule of law, then people will be stopped, initial contact, in a way that they never should have been stopped. They might be searched in a way that is an offense to the rule of law and to civil liberties. And so it really is important to sort of, when we're talking about, criminal justice in a democratic society, police play a huge role in that. And so, it's essential that those who enforce the law abide by the rule of law. And, that's true for any agent within the criminal justice system. It's also important that prosecutors who enforce prosecution abide by the rule of law, judges, those who are administering corrections within correctional facilities. Everybody should follow the rule of law, but it's most essential for those who are working within the criminal justice system. And so when we talk about the rule of law, what are we talking about? I think a lot of you might be familiar with that term, rule of law, but I just wanted to make sure that we were all on the same page as we were thinking about police and the rule of law. Basically the rule of law, and it's a cornerstone of democratic society, that it's the idea that no one is above the law, right? It doesn't matter what position you hold in society, that everybody is held accountable to the same laws. So it doesn't matter whether you're a police officer, it doesn't matter if you're a prosecutor, it doesn't matter if you're the president, it doesn't matter if you're a senator, it does not matter who you are in the society, right? That we are all accountable to the same laws. And so no one is above the law, no one is below the law, and that also another aspect of rule of law is that everybody is treated equally under the law. And so as you sort of think about the different perspectives we've learned about this semester, definitely the due process perspective falls into this assurance that those in the criminal justice system abide by the rule of law. So much of the law that governs the actions of police and of other criminal justice agents and institutions are derived from the Bill of Rights. In the Bill of Rights, I think most of you know, but just to make sure we all know, that the Bill of Rights are the first 10 amendments to the United States Constitution. When the Constitution was initially ratified, it was ratified without a Bill of Rights. And that was a problem, that the states who were ratifying this new Constitution that gives a lot of power to the federal government, they were really worried that without a Bill of Rights, that the federal government would abuse its powers. And so those seeking ratification from the states promised the states that if you ratify the Constitution without the Bill of Rights, our first act of Congress will be to add a Bill of Rights. And indeed it was, right? So the Constitution is ratified in 1788, and then the first Congress of the United States builds the Bill of Rights, James Madison, and that they are adopted in ratified in 1791. And so the Bill of Rights encompasses what we refer to as civil liberties. Okay, so I teach a class on civil liberties, and so our whole semester is basically looking at these liberties that are outlined, or freedoms that are outlined in the Bill of Rights. And so when I teach civil liberties, and when we're thinking about civil liberties in relationship to law enforcement, I want, civil liberties are the individual rights and personal freedoms from which government are constrained from interfering with. And I oftentimes tell my student that the Bill of Rights, those civil liberties, that they're telling government what it can't do. It's restraining the actions of government, okay? And so that when you look at the Bill of Rights, it's saying that, Congress, and that refers to the states and cities as well, cannot do certain things, right? They can't abridge your speech. They can't establish a religion. And so all of the Bill of Rights is these restraints, these thou shalt nots. It's telling government what they can't do, and by telling government what they can't do, it opens up a space for personal freedom. And in the case of the rights of the criminally accused, it opens up protections from the abuse, or it guarantees protections for those accused of crime from the government, making sure that they don't abuse their power. A lot of the Bill of Rights is dedicated to the rights of the criminally accused, and we'll take a look at those in a second. And so 4 of the 10 amendments in the Bill of Rights address the rights of the criminally accused. And those 4 amendments, as we're going to be learning about, starting that today, but really kind of continuing throughout the course of the semester with some of the other amendments, each of those amendments carry a multitude of restraints that are placed on government and rights that are afforded to those who are criminally accused. So let's take a look at those 4 amendments that address the rights of the criminally accused. So Amendment 4 through 8 are the ones that are dedicated in the Bill of Rights to protecting those who are accused of crimes. And in this lecture, we're going to be looking at the 4th Amendment, not just this lecture, but this week we're going to be looking at the 4th Amendment, but you're also going to be learning about in the textbook portion of the 5th Amendment that applies to police and the rule of law. And so the 4th Amendment obviously implicates the police, or basically refers to the police or affects the police and the way that they behave, because the 4th Amendment deals with searches, seizures, and the issuance of warrants. Okay, all of the things that either police officers engage in, search and seizures and arrests, but also getting a warrant from a judge in order to engage in a legal search. The 5th Amendment also deals with the rights of the criminally accused, only one of which of those rights you're going to be learning about in this topic, which is the right to remain silent. And so the 5th Amendment, though, tells us that individuals, that if their life, liberty, or property is going to be taken away from them, that it needs to follow the due process of law. And so the due process clause is in the 5th Amendment. It's also in the 14th Amendment. It tells us that you have a right to a grand jury if you are going to be indicted for a crime. That liberty has actually never been incorporated into the states, but again, it's a right of the criminally accused. People can't be tried twice for the same crime. In other words, a prosecutor can't keep if a prosecutor prosecutor charges and tries somebody and they don't get the outcome they want, they didn't get a guilty verdict, they can't keep going back and going back and going back and retrying them until they get the outcome that they are looking for, because obviously that would be an abuse of power. But the Fifth Amendment also tells us that those who are accused of crimes that or suspected of crimes, that they have the right to remain silent. They can't be forced to incriminate themselves. And so that does trigger law enforcement, because law enforcement are often the ones who are doing the questioning of those who have been arrested. Okay. And so the right to remain silent, the Miranda warning that you get, basically is telling, is a product of the Fifth Amendment. The Sixth Amendment, we're not going to be talking about in this lecture, but later when we get to the court system, the Sixth Amendment deals with trial rights, that you have a right to a speedy trial, that you have a right to a jury trial that's made up of your peers, and not most importantly, but importantly, the Sixth Amendment also tells us that you have the right to the assistance of counsel. And then at the end of the semester, we're going to be learning about the corrections. So we're going to be talking about punishment, but we're also going to do a special focus on the death penalty. And, that implicates the Eighth Amendment, because the government is prohibited or restrained from placing an excessive bail on somebody as they wait to prepare for trial, and that there can't be an excessive fine, and also that a person cannot be sentenced by a judge to a punishment that is considered cruel and unusual. And so a lot of the Bill of Rights is dedicated to the rights of the criminally accused, and I think that's in large part a reflection of that when you live in a democratic society, you want to make sure that those who are most likely to be denied their rights, those accused of crimes, are given their rights. Because if you put people behind bars and the people you put behind bars do not have any rights, and we don't abide by those rights, that really is basically maybe the first step to the erosion of the rights. And also it's easy to interfere with or deny the rights to those who are accused of crimes. You're like, they're probably guilty anyways, right? And so our framers of the Constitution were very mindful of that. They knew that the first place the power would be abused would be most likely be on those who are criminally accused. So they wanted to make sure that there was robust protections as this cornerstone to democratic society. All right, so let's turn our sights to the Fourth Amendment, because that's what we're going to be talking about in both of our lectures this week. So the Fourth Amendment is about privacy, okay? That it basically is placing limits on government power as it relates to privacy. Because as we know, the Fourth Amendment deals with searches, and it's basically telling government that it can only enter into these places that are private places only if they have a warrant and have probable cause, okay? And so it's basically, placing a barrier on government from intruding into our private places. Now, the Fourth Amendment does two things. One thing it does is it places limits on the power of the police during search and seizure. And so that the Fourth Amendment is basically telling police that they can't engage in an unreasonable search, and for a search to be reasonable, it has to be based on probable cause, and that it has to most often the search needs to have a warrant as well. And so it places limit on the power of police when it comes to arresting somebody, because an arrest is a seizure, and so arrests need to be based on probable cause, and oftentimes that you get a warrant for arrest as well. It obviously places limits on the power to search people's property, and also gives us guidance in terms of what kinds of objects, or not what kinds, but that what needs to be placed in order to seize an object or seize some sort of contraband like drugs or weapons. And so it places limits on the power of arresting, searching, and also then seizing the products of those searches. The other thing that the Fourth Amendment does is it tells us what are the requirements for a legal warrant, okay? And so let's look on the next slide, because then we'll be able there to see the language of the Fourth Amendment, and we'll see the two clauses that are associated with the Fourth Amendment. Okay, so here is the language of the Fourth Amendment. The first part of the Fourth Amendment says that the right of the people to be secure in their persons, houses, papers, and effects against unreasonable search and seizure shall not be violated. And that is what is known as the reasonable clause, okay? And so it's basically telling government that they cannot violate the rights of the people to be secure in their homes, in their body, their person, of the things that are in their home or their personal effects that might be outside of their home. And in other words, that can't be violated in an unreasonable manner. Okay. And we're going to talk about what we mean by reasonableness in a moment. And it's the Supreme Court that gives us guidance on what's considered a reasonable search. And so that part of the Fourth Amendment is called the reasonable clause because it's saying that you can search, government can search, but that the search must be reasonable. The other part of the Fourth Amendment, it continues. It says the seizure that shall not be violated, and no warrants shall issue but upon probable cause, supported by oath or affirmation, and particularly describing the place to be searched and the persons or things to be seized. Okay, and we're going to talk more about the requirements for a warrant later in the lecture. And so that's what's known as the Warrants Clause. Okay, so we don't go into great depth, although there are a lot of cool cases that you'll be reading and that we'll be referencing throughout the course of these lectures today. So you might sometimes see as you continue your studies, if you do, hopefully in civil liberties or the rule of law as applies to law enforcement, you may see the reasonable clause referred to or the warrants clause referred to. And here, hopefully, you get a good understanding about what those two mean. Okay, so the word search that's used in the Fourth Amendment is used in a very specific way. It has a very specific meaning. And so as it says there, the search that's used in the Fourth Amendment is not anyone looking for something, okay? In the context of the Fourth Amendment, the search has a very distinct meaning. And that meaning is that it's a government agent's infringement on a person's reasonable expectation of privacy, okay? And we'll talk a little bit about that as we move forward. So what I want you to keep in mind and to remember is that, the Bill of Rights, the Fourth Amendment, it's telling government what it can't do. And so in the Fourth Amendment, it's saying government agents cannot engage in an unreasonable search, okay? And so when we're talking about the word search in the Fourth Amendment, it doesn't mean anybody searching for something. It really is a police search because the police are a part of the government. We'll talk about the reasonable expectation of privacy in a moment. And so keep in mind that just because somebody engages in a search of your private things doesn't mean that the Fourth Amendment has been violated. So for example, if you are in a a privately owned mall like Brookfield Square or, what other malls you might go to, and there might be private security guards that the mall hires. Well, if they follow you around the outside and in the store, they think you've stolen something and they stop and you're still in the mall itself and you're searched. That's not a Fourth Amendment search. That mall security is a private actor, and so they can that would not trigger the Fourth Amendment. A private employer can search your locker at work. They're not a government actor. Friend rifles through your things, find something, they can even turn it over to the cops. But the Fourth Amendment has not been triggered, okay? So, don't get caught up too much on that. There can be laws within specific states that say that if these individuals engage in those acts, that they might be prohibited from engaging in those acts. But here we're just talking about the Fourth Amendment. When the Fourth Amendment uses the word search, they're talking about a police search, a government agent doing that search. Okay, so the Fourth Amendment is talking about a police search where a government agent is engaging in a search. But another part of the Fourth Amendment is that in the context of the Fourth Amendment, for there to be a search, it must be of a place where one reasonably expects privacy. So it has to be a government agent that is engaging in that search. But for that search to be considered unreasonable, that it has to be a search of a place where one expects a reasonable sense of privacy, right? And we're going to use some examples in a second to try to figure out, okay, well, what is a place that's being searched where one has a reasonable expectation of privacy? And it's the Supreme Court who tells us when some area is being searched, it's the Supreme Court that tells us, you know what, there is a reasonable expectation of privacy around that thing that's being searched. And therefore, if you want to search that thing, you need to have either probable cause or a warrant. And so if searching a private place triggers the Fourth Amendment. So if the thing that you're searching is a place or an effect where one has a reasonable expectation of privacy, then the Fourth Amendment is triggered. You've got to have probable cause or a warrant. But if the place that's being searched is not private, if there's no reasonable expectation of privacy that the thing that's being searched, hey, this isn't a private place, this is maybe more of a public place, then the Fourth Amendment is not triggered. So if the place is not considered private, then a search has not occurred, and therefore you don't need a warrant and you don't need probable cause. So let's look at some examples and see if we can figure out, hey, does this search trigger the Fourth Amendment because it's searching a private place? Or is this not a private place where there's no reasonable expectation of privacy, therefore it does not trigger the Fourth Amendment? Okay, so as I do sometimes in our lectures, try to keep it sort of interactive, that what I'm going to do is I'm going to put up some hypothetical situations here, and I want you to then, after you see the hypotheticals, I want you to turn off the video or pause it, and then I want you to ask yourself, do you think there's a reasonable expectation of privacy as it relates to these hypotheticals? Then we'll come back and we'll talk about, well, which ones do, where there is a reasonable expectation of privacy. And so that way it gives you an opportunity to sort of think critically or apply what you're learning about reasonable expectation of privacy to some concrete hypotheticals. Okay, let's say you are having a conversation with your friend on the couch in your living room inside your house. Do you think that it's reasonable to expect that that is a private conversation, that what's going on in your living room is private? In other words, is there reasonable expectation of privacy? And if cops want to intrude on that, it triggers the Fourth Amendment, that they're going to need a warrant or probable cause. What about this one? You're having a conversation with your friend on a park bench in a public park. Go down the street, sit on a public bench, just start having a conversation. Do you think there's a reasonable expectation of privacy there, that conversation? How about you put trash in a can and place it on the street for pickup? So I live in Milwaukee. We put our garbage in a garbage can that's outside in the alleyway. Is it reasonable to think that what's in my trash can is private and that if you want to search it, you need a warrant? Or do you think, no, there's no reasonable expectation of that what's in your trash can is in fact private? What if I put my trash can put my trash in a trash can and I left it on my porch? Do we have reasonable expectation of privacy for the trash that's in the can on the porch that's connected to your house? How about police use a thermal device to collect the temperature data of your basement? Okay, so let's say that cops are sitting outside there with the thermal measuring device. They don't have to be close to your house. They don't come on your property, but they're sitting in their cop car on the street and they extend this device out the car and it's able to measure how hot your basement is. Because if your basement's hot, well, you might be growing some pot down there. Is that a violation of your privacy? Is it reasonable to think that what goes on in your basement is a private place? Even though they're not on your property and they're not intruding into your house, is that thermal device invading a person's reasonable expectation of privacy? What if police use a drone and fly over your backyard and take pictures? Okay, it's well above your house. It's looking down into your backyard. Sees you growing some pot back there. Hopefully, this won't be an issue in the future when we legalize pot. But that is that a violation of a person's reasonable expectation of privacy? How about police and using facial recognition in a public airport? Does that violate a person's reasonable expectation of privacy? Okay, so turn the machine off, and then we'll come back together and we'll talk about whether or not these would trigger the Fourth. All right, so welcome back. So let's take a look at the hypotheticals and see whether there is a reasonable expectation of privacy in these different instances. All right, so you're having a conversation with your friend on the couch in your living room inside your house. Yes, there's a reasonable expectation of privacy there. It's private. It triggers the Fourth Amendment. If the cops want to come in there, they're going to need a warrant or probable cause. And I put it in red because it's like, stop. Cops, it does trigger the Fourth Amendment. And so it places a restraint on government actors. You're having a conversation with your friend on a park bench in a public park. Nope, that's not considered. It's not reasonable to think that that conversation is private. So if cops want to sit next to you and listen in on your conversation, they don't need a warrant to do that. So green. You put trash in a can and place it on the street for pickup. Again, that's in green. No, there is not a reasonable expectation of privacy there. It is considered abandoned property. And so that you basically had trash, you put it in a can, you put it on the street's in a public area. There's no reasonable expectation of privacy. Abandoned property. So green light. You put trash in a can on your porch. Stop. Yes, there is a reasonable expectation of privacy. Why? Because your porch is considered an extension of your house. And so that's what's known as curtilage. And the Supreme Court has said that even though that can's outside on a porch, it's still on your property, and there's a reasonable expectation of privacy on your property, even if it's not directly inside your house. Police use a thermal device to collect temperature data on your basement. Red light. That is a violation of one's reasonable expectation of privacy. And so this is a famous case. You'll be reading about it in your textbook. It's where the cops were using that thermal device, and they actually got a reading that was real higher than the basements of other people on the street, and they used that for probable cause to get a warrant and to search. And the Supreme Court said no, that what goes on your basement is private, and that using those kinds of thermal devices are an intrusion into that private space. It's not reasonable, or it's unreasonable to do that. Police use a drone to fly over your backyard and take pictures. Nope, there's no reasonable expectation of privacy there. Now, if cops are walking by your backyard and there's a really big fence, and then they get a ladder and they're looking over into the backyard, that is a violation of your reasonable expectation of privacy, and that would be illegal for cops to do that. But the court said in this case that the airspace is as long as it's X number of feet above your property, it's airspace, and that what happens over the airspace in your backyard, and people look down from an airplane, there's no reasonable expectation of privacy. Green, don't need a warrant, doesn't trigger the fourth. And that police use facial recognition technology in public airport. Yeah, there's no expectation of privacy there either. It's a public space. People can see you. They could take pictures of you. So could government agents. Okay. And so that's the breakdown in terms of whether or not it triggers the Fourth Amendment. Okay. So, people do have a right to be private, to be free from government intrusion into their privacy. But this right is not absolute. I tell my civil liberties students this all of the time, that you have the right to freely speak, you have the right to exercise your religion, you have the right to peaceably assemble, you have the right to bear arms, the list goes on. There are a lot of personal rights that we have, but they are not absolute. And there are many times where the government has a really good reason for intruding upon your privacy. So oftentimes civil liberties is sort of a balance between the rights of the individual and the interests of the state. And there are often times when the interest of the state is very compelling, and as such that they have a justification for violating your rights, and a justification in this case of intruding into your privacy. Because there's a lot of reasons why government may need to intrude into your privacy. That if you are privately running a meth lab in your basement, right? Sure, that's a private space, but the damage that's coming from the production of the meth harms others. The production of meth harms others. And so that harm is substantial. And so that even though that activity is taking place in a private endeavor, that the government has a real good reason for intruding upon that privacy. The good reason being to prevent harm, to prevent the production of a dangerous controlled substance. So government may need to intrude into this privacy, but to do this, they need a substantial reason to intrude. And so government, and that's where that limit on government comes. Government can intrude on your privacy, but they have to have a really good reason to do that. And that substantial reason for searches is called probable cause, okay? So for government to intrude in your privacy, that they must have a reason, and that substantial reason is known as probable cause. And probable cause, even though it's not defined in the Constitution, it's been defined by the courts and by law as that it says that probable cause means that it's reasonable to believe based on the evidence that a crime has or is being committed, okay? And so in order to engage in a search, that the law enforcement the government agent needs to demonstrate that there's this evidence, that they have evidence, and the evidence is saying that based on the evidence, it's reasonable to believe that a crime is being committed, okay? Now keep in mind the burden of proof of probable cause is lower than like a higher standard, like the standard one needs to convict somebody of a crime, which is beyond a reasonable doubt. So even though there might be probable cause that you engaged in a crime, evidence that you engaged in a crime, there could be a reasonable explanation for that evidence, could say it's probable that a crime's going on here. But then once you investigate more and more and more, you might find that no, that a crime has not been committed beyond a reasonable doubt. So this is a lower standard. It is a standard, but it's a lower standard that enables police to engage in a search. So let's turn our sights to the second part of the Fourth Amendment, which is the Warrants Clause. So as we saw in the Warrants Clause of the Fourth Amendment, that there are certain requirements that must be satisfied before a warrant could be issued. And there are 3 requirements that must be satisfied. So when you look at the Warrants Clause, it's basically saying that to get a warrant, it must be based on probable cause, which we just talked about, that based on the evidence, it's reasonable to think that a crime has been committed. That the warrant must be issued by a judge or a magistrate, an agent of the court, and that it must possess a particularity. That is that the warrant, it designates what is to be searched, right? Because that the search needs to be, related to the probable cause that a crime has been committed. So the particularity of that search warrant is searching for things that are related to the crime that it's reasonable to think that this person has committed. So we went over probable cause, but maybe think about, well, why do warrants need to be issued by judges, right? Somebody from the courts. Well, separation of powers, right? Law enforcement have a particular job. They are enforcing the law. They are trying to, arrest wrongdoers, right? So, think about it. If we let law enforcement issue their own warrants, it wouldn't really be a check on the power of law enforcement. They'd be issuing, oh, sure, that's probable cause, right? I'm not saying that's what would happen. But when law enforcement go to somebody in a different branch of government, judges are in the judiciary branch, then the judge is, has a different interest, right? The judge is maybe interest not solely in enforcement of the law or crime fighting, but they're making sure that due process is upheld. And so the judge has a different interest, and they're who want to make sure that the evidence that the law enforcement present is in fact substantiates the claim of probable cause. And particularity, as we talked about, is that the warrants are going to have specifically where it's going to be searched. Search can be broad based on the crime, the evidence of the crime that's been committed. It can be very specific as well. And you'll read more about that in your textbook. Okay, so while getting a warrant to search is preferred, of course you want go to the judge, make sure that there's probable cause, get a warrant, present the warrant, search the particular place. Of course getting a search warrant is preferred, but it's not always practical. It takes a lot of time to get a warrant, and that sometimes when a place needs to be searched, that you can't really wait to search it, right? It might be an emergency situation. It might be that you've pulled somebody over in a car. I mean, there are many circumstances that where if you waited to get a search warrant, then it's possible that either the evidence would disappear or that the criminal would have or the accused might have a chance to get away. And so there are times when it's reasonable to waive the warrant requirement. And that, that means that when you waive the warrant requirement, it means that you can search somebody without a warrant. And they're known as exceptions to the warrant requirement, or warrantless searches. Searches without a warrant can be legal, okay? Just because a cop doesn't have a warrant doesn't mean that it is an illegal or an unreasonable search. And so we're going to be learning more about warrantless searches in Lecture 2. So thanks a lot for paying attention, and I'll talk to you again soon.